In this video, I will talk about misrepresentation and malpractices which happens in the corporate world. If there are any misrepresentations and malpractices, that definitely results in either a civil trial or criminal trial. So what is the difference between civil trial and criminal trial? We are going to discuss in this video. Before getting on to the video, if you have still not subscribed to our channel, please subscribe. If you like this video, please press the like button and then share it to your friends. What is misrepresentation and malpractices? There are various instances where, when it comes to the provisions of Companies Act itself, misrepresentation in the prospectus by the promoters are punishable offence. Any investor who wants to invest in the securities of a particular company, he will be trusting the promoters. Based on whatever statements they have made in the prospectus and considering the growth prospects of the company, keeping in mind that if I invest in this particular company, my money grows and then there will be a very good return of investment. Going by the promises which is being done by the promoter, we will invest in that particular company. If that particular prospectus itself happens to be a misstated one, or if there is a sort of misrepresentation, then don't you think that he has to be penalized? So there is penal consequences which is required to be faced when it comes to misstatement in the prospectus. The same way, if you look at, there are a lot of malpractices also which is going to happen in the corporate world, because it is a fiduciary relationship or a sort of fiduciary duty. Shareholders will entrust upon the promoters, and when the board of directors will be framed, generally promoters will be part of the members of the board and they will be sitting as the chairman also, so that the entire substantial powers of the management will be vested in them. The shareholders will be overseeing the activity by looking at by participating in the meetings and then looking at various resolutions. And that happens to be a very serious issue wherein there is a lot of malpractices which is happening in the company. Fraud is one of the important malpractice which we have seen as an example, and there might be breach of duty, there might be breach of trust, there might be some sort of a negligent activities. All these things would result in the corporate malpractices where the directors would be using the company's funds for their personal benefits, and then they will be deviating the corporate funds for their own benefit or for the benefit of their own related parties. Like that, there are a lot of malpractices which might happen in the corporate world. So generally, like, the misrepresentation and malpractices will necessarily result in civil and criminal trial. If it is of civil nature, if the default is of civil nature, then civil trial will happen. If the default is of criminal nature, then the criminal trial is going to happen. Please note, National Company Law Tribunal is the civil court where it is guided by the principles of Code of Civil Procedure, whereas the special courts which is being established as per the provisions of Companies Act 2013 are guided by the Code of Criminal Procedure. Generally, like, if I have to take the example, like majority of the mismanagement related cases, they are of civil nature, that will necessarily end up in the National Company Law Tribunal. If it ends up in the National Company Law Tribunal, what is the procedure which will be followed in NCLT? If you look at in NCLT, take for example, a group of shareholders has submitted a petition for mismanagement or malpractices related issues, then the first important activity what is going to happen is the National Company Law Tribunal will send summons to the opposite party. Here the shareholders are the petitioners and the respondents will be the board of directors as well as the company itself. Now the board of directors has to receive the summons and then the written submission will be given by the company. And once the written submission is provided, there will be discovery of documents. Please note, to validate that there is a mismanagement which has happened in the company, there will be a lot of documents which will be given as a supporting evidence by the petitioners, and respondent, to protect themselves, to defend themselves, they would come out with, there are so many important documents in the form of written submission as well as the documentary evidences they can give. Under those circumstances, there will be discovery of documents, and if the petition is getting admitted, the hearing may happen. The evidence will be both the types, documentary evidences as oral evidences. If oral evidences is necessary, generally like civil courts will keep oral evidences at the last hierarchy, whereas it will be primarily based on the documentary evidences. The scrutiny of the documentary evidences is going to happen, and in the stage of hearing, basically hearing will be given and then basically a hearing. Once the hearing is completed, there will be examination of the issues will be framed, the examination is going to happen, and once all the examination as well as hearing is done, then finally the civil court will pass an order, whether there is a mismanagement, is there any requirement to basically like order any penalty, and finally the reasoning will be given in the form of the judgment. This is how the civil trial is going to happen. And how the National Company Law Tribunal works, it will be working in the same way. I have tried to summarize it in a very simple form. When it comes to the criminal trial, please note, in the fundamental elements of criminal law, that is under the Code of Criminal Procedure, the cases are divided into summons cases and warrants cases. Please note, summons cases is defined as the one which is not a warrant case, it is summons case. Warrant case means a case where the penalty is death sentence or imprisonment which is more than 2 years, it will be called as warrant cases. And whatever is not a warrant case, it will be considered as a summons case. In majority of the company law related issues, it is summons cases itself. Only if the punishment is, the imprisonment is more than 2 years, if it is specifically mentioned in any of the default, whether it is in the provisions of company law or any other corporate laws or any other law which is applicable to the company, which is imprisonment is more than 2 years, then only it will be coming under the category of warrants case. The criminal trial happens this way. These all are the procedure which will be necessarily followed. The first important thing will be, upon receipt of a complaint, service of summons has to happen. What is the procedure of servicing the summons? Who has to necessarily do this activity of summons? And once the summons is sent to the opposite party, the next important step will be framing of the charges. The charges is how we will frame the issues in the case of Code of Civil Procedure. We will frame the charges in case of criminal procedure. What are the charges against him? Like he has committed a fraud by way of taking into his personal accounts 1 crore worth money. So like that, there are so many issues which will be formed in the, it will be called as framing of the charges. And during this particular process, when the charges are framed, the opportunity will be given to the opposite party to admit his guilt. If he admits the guilt, then the prosecution will come to an end and penal consequences he has to follow. If he does not admit it, if he denies it, then it goes to the next step. That is, hearing is going to happen, and then it will go to the evidence stage where both the parties will submit the evidences. Arguments will be framed on the charges, and there will be examination and cross-examination which is going to happen. And after this stage, finally the court will come to the conclusion whether that particular person has to be acquitted. That means if he is not guilty, he will be sent off, he will be acquitted, and then he will be convicted if in the examination as well as cross-examination if the guilt is proved. So this is what the fundamental elements which we have to necessarily keep in mind, like what is the procedure, the trial procedure in civil cases, and what is the trial procedure in criminal cases. Because in the career of company secretary, since company secretaries are also officers who is in default for certain important non-compliances, we should be necessarily aware of how the civil trial and criminal trial happens. If you want to learn more about this particular course, please fill up the Google form which is being provided in the description box below. If you have any questions associated to this particular video, please comment. If you want to know more about the courses offered by Ekcel Academy, please visit our website www.ekcelacademy.com. Thank you.